Once we concede, Mr. Sibal, that concede in the sense for the purpose of the we're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Mullah, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Mullah, we have to find the modality within the constitution, not outside it, not vested in an executive power of the union. That cannot be. So if your lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370 bracket 3 itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests in the state. So if you say that C70 sub-article 3 provides that solution, well, that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal, no. When you argue, then we'll have to take one. 368 is power to amend the Constitution. That's certainly there.
Yeah.
Now, when we look at 370, clause 3, now the issue would be whether 368 power is still available to amend the Constitution.
But your lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368.
Yeah.
370.
Including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional power.
It's not action under 368. Your lordships are not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368 you can do it under 368?
So 368 is the power to amend the Constitution.
We are not. Are we concerned with that here? I'm sorry, Malaj. You require 2/3. You represent.
There are independent avenues. You have the power to amend.
Malaj,
you have the power within 370 to abrogate.
But Malaj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution, no avenue at all.
Mr. Sibal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370. If we forget about the proviso.
I'm sorry to say that, Malaj. I'm really
Just
sorry.
There is a proviso. Once again.
You can't exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the proviso.
Clause 370 comes into play on the recommendation of the Constituent Assembly. Your lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the president will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will a proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. Well, you'll have to interpret it on its plain terms, Bharat, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's at the heart of federalism, is this, Bharat. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way. And whereas 373 power has been exercised by the Constituent Assembly, saying no recommendation. And I'll come to your lordships a judgment of Sampath Prakash Maharaj, which actually deals with this issue. So let's be clear, Maharaj. Sorry.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the, it only says that it only exercises the three choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. So out of three, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let's go back. Let's go back, Maharaj, to 1950, 26th of January, right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? Parliament, there was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Maharaj. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. It was not temporary because this provision had to go. No. And therefore, Maharaj, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role at that point in time. And the government of India in 1950, in Parliament, recognized that it is the Constituent Assembly on the recommendation of which 370 will be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, Maharaj, if 370 had been abrogated. It would be yet another state of India.
Mr. Sibal, you've made your point now. I think basically as we see it, your argument is in three layers. We looked at the background, the history. We look at 370 in the background, the constitutional history, the other history which we saw pre-independence. We interpret 370 therefore in the context of that history. And then we've gone to the modalities which were followed for abrogation, which you have said is unconstitutional. Now, after having explored this terrain,
let's
which is the next, how do we now
come back to the list of dates, Maharaj.
Right.
In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36 and 38, governor could only act on the aid and advice of the Council of Ministers. That's the Jammu Kashmir Constitution. The governor could not represent the state. There is no Council of Ministers. So you create a constitutional myth and assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery, which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. D is even more serious. I don't think in any constitutional democracy in the world this has happened, Mullah. In the famous Miller case in the UK, Mullah, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, Mullah, matter came to the Supreme Court. All the justices of the court said, "No, Mullah, your Lordship knows this is the executive power of the government. They can prorogue the House." But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor which he does not have. You assume to yourself under 356 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression constituent assembly of the state referred to in clause 2 shall be the legislative assembly of the state. What power does the president have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power.
Just as a test, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place for their constitutional design of ultimately abrogating 370. Why was this amendment to 367 necessary?
Because, brothers, they themselves gave the power of the legislative assembly, which they were exercising in 356 as the constituent assembly, and recommended. They were ad item with my interpretation.
Yes.
They were ad item with my interpretation.
Right.
That you needed the recommendation of the Constituent Assembly. So how do you reach there?
They constituted the Legislative Assembly as the Constituent Assembly.
And what they do is they don't interpret it. They say in Proviso 3 of 370, the expression Constituent Assembly of the state referred to in clause 3 shall read as Legislative Assembly. So they have amended Article 370 of the Constitution.
Actually,
Shall read as
367 amendment was not required because you exercising power under clause 1 to say article.
No, it was required because you needed the recommendation of the Constituent Assembly.
No, that's something separate. But in 367, introducing clause 4, in terms of the notification dated 5th August 2019.
You required it because they changed the definition of Constituent Assembly in 370 as Legislative Assembly. This is why they could exercise power under 356. Please appreciate.
But suppose for a moment that they had not gone through this exercise of amending 367, all right, or introducing 367(4), and suppose we are operating purely within the fold of 356.
Yes.
All right, your challenge to the 356 notification is a different issue.
Yes.
You're now just testing it as an exercise of power under 356. Once a proclamation takes place under 356, two consequences follow. One, the president assumes to herself all the powers of the state, the executive powers of the state vest in the president. Two, except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the president.
Correct.
All the powers of the state legislature were vested in parliament.
Right.
Now, if that was so, then if 370(3) is capable of the interpretation, just as a hypothesis, that it's a power to be exercised by the president to abrogate. They abrogate. Point number two, any powers which were to be exercised by the state legislature would have to be exercised by parliament. So they had to go to parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by parliament, by the governor, by the president and parliament in this fashion. independent of 367. Cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature. Under 356, Bomai has held that. You have no such powers. And the executive is only dealing with the administration. It can't amend the constitution under 356. Therefore, they'd had to do this. There was no choice.